It's also a distinct honor to introduce the next speaker, who is Shanin Specter. He is one of the leading trial lawyers in the country, having obtained over more than 200 verdicts and settlements in excess of $1 million, including jury verdicts of $153 million against a major automaker and $109 million against a Western Pennsylvania power company. He has achieved 16 8- or 9-figure verdicts, many of them news-making and headline-making cases involving medical malpractice, defective products, medical devices, personal liability, auto accidents, general negligence. One of his cases, he waged an epic battle against Ford Motor Company on behalf of the family of Walter White, who was a 3-year-old boy who was run over and killed when the parking brake of his father's F-350 spontaneously disengaged. He won 2 verdicts, actually, in White versus Ford for $153 million and $52 million, and eventually litigated the case to settlement. And his efforts were chronicled in the book Bad Break, which I believe is outside for your interest. But more than that, he is in the tradition of Nader Brandeis, he's a public lawyer. He is not satisfied with bringing cases and winning cases. He is concerned about deterrence and reform. So that's why he has not only for years taught a course called Civil Justice as an Agent of Change, but each time he gets into a case, he then seeks to promote substantial reforms. So, for example, most recently, he got the city of Philadelphia for the first time, after representing a victim of a fire escape collapse, to enact an ordinance that for the first time will require that all fire escapes be regularly inspected by independent structural engineers. So he is both an attorney advocate for his clients, but also a reformer that takes on the tough issues for the country. If you would welcome warmly Shanin Specter.
Well, thank you for those very too generous remarks. I am told that I am all that is standing between you and lunch. So I'm going to be mindful of that, but I do beg your indulgence. I know you've had a very long and intellectually stimulating and rigorous program this morning, but I do beg your indulgence for a few minutes to consider some thoughts that I have. I feel lucky to be here. I drove 140 miles through a continuous and driving rainstorm, but when Ralph Nader summons you, it is equivalent to an order of court. And I feel so deeply indebted to Ralph Nader. I think all of us in America, and really citizens of the world, are indebted to Ralph Nader because of what he has done to promote public safety. My hair is largely gray, so this is somewhat embarrassing to say for at least some of you to listen to, perhaps, but ever since I was in grade school, I have followed what Ralph Nader has done, beginning with unsafe at any speed and reforming the car companies, or at least trying to, and taking it from there. And so much of what we rely on today for our public safety and our health comes from Ralph Nader and those who have followed him. So when I'm handling a case for a client, or trying a case in court, or making demands on a defendant to reform themselves, I feel that I am channeling Ralph Nader. And I am proud to do that. So I want to talk to you today about the idea of using civil litigation as an agent of change for your clients, for the defendant themselves, for society and for your law practice and yourself. It's not really commonly understood in the vast swath of America that people who were badly injured, who have a loved one badly injured or a loved one who's been killed, who come to see a lawyer, they are not just seeking fair compensation for what's happened. They are seeking reform. They don't want to see this happen again. Now, I recognize that there are some cases that are not really amenable to that kind of an argument. Somebody perhaps is negligent and they go through a red light in an intersection and they're involved in a bad accident and somebody else files suit against them. I certainly see that we don't necessarily have a case that cries out for structural reform. But so many other of the cases that come to lawyers today are cases where, if they give it some thought, they can bring to bear their skills and their talents in such a way as to convince the defendant to change their ways. Now, of course, we have a weakness in the civil justice system in this country because we can only sue for money damages. We're not allowed to bring a claim in this country for equitable reform. It's just not part of what is permitted in the tort system or the justice system writ large. But we have leverage that is not well appreciated by trial lawyers, and that leverage is the hot breath of jury selection, jury trial, verdict, publicity, public censure, government oversight, and all that goes with that. So, in the right case, we can make a demand on a defendant that as a condition of settlement, that they have to change their practices. And I have found good success in getting that done. Let me just, though, if I could, segment out why everybody in the system either does want to see that done or with a little bit of convincing will want to see that done. First of all, our clients. As I mentioned before, people who come to see me, yes, they want compensation, but they also want reform. So it requires no convincing of my clients to seek reform of defendants' practices. Zero. Let's talk for a moment about the defendants. We lawyers don't have a great window into the defendant's thinking about the conduct that gave rise to the injury that's the subject of a lawsuit. But based upon discussions I've had long after the case was over, or based upon discussions as part of settlement negotiations, I have come to the view that in many situations, defendants welcome the idea of introspection and the idea of making their practice and their conduct safer. We have seen significant strides in this area, for example, in the healthcare field, where hospitals more recently have become much more open about improving their practices, about sitting down with their physicians and their other healthcare providers when a mistake has been made and having it be a true teaching moment. They've made progress with respect to talking to their patients about why there's been a bad outcome. Sometimes that has been required by statute. We have such a law in Pennsylvania where there must be a disclosure to a patient of an outcome that was unexpected and the reasons for that unexpected outcome. And so in the hospital setting, there was much greater receptivity than in years past. I had a case recently where a doctor in an emergency room did not know how to recognize and treat a stroke. Hard to imagine that could be true in the United States, but it was, and a man was horribly injured as a result. And in discussing that case with the defendants, and knowing what I knew about this physician who had failed his board examinations 8 times, after obtaining client authority, I told the hospital that the case would not be settled unless the doctor was removed from the medical staff of the hospital. Frankly, it surprised me that he hadn't been removed already. And I'm not sure why that had been. Perhaps they were concerned that it would be somehow an admission of responsibility, liability by doing so. But they hadn't done that. But when I approached them and told them that, I got no resistance. None. And so the case was settled, and the doctor was kicked off the hospital staff. And of course, that's not a complete answer because maybe he can go practice somewhere else, and there are limits on what I can do as a lawyer, obviously. But I felt good. I think we should all feel good about the justice system in that situation, because not only did a family receive compensation, but a community was ridden of a physician who was incompetent to practice emergency medicine. And that's an important improvement. So I think defendants are willing to listen. They often don't want you to talk about what you've accomplished. So I respect that too. I think you got to be willing as a lawyer not to brag about your accomplishments if you can attain a real societal benefit. So I had a car company whose name I can't mention that sold vehicles in some foreign countries without seatbelts in all seating positions. And a young woman was killed when she was thrown out of a vehicle in Morocco. And I said to the car company, this case will not be settled unless you supply vehicles with seatbelts in all seating positions, any vehicle you sell anywhere in the world, regardless of whether the laws of that country require those seatbelts. And they did that. And I think they might have done it even without my requiring it. Of course, they wouldn't tell me that. But it was so obvious that they should do that. But they needed somebody to prod them. We had a bad situation in Philadelphia with our police department, where our officers received inadequate training in the operation of police vehicles, and where we had extraordinarily lax regulations with respect to the operation of these vehicles, which essentially gave them a license to operate them however they saw fit on our busy city streets. And 2 people were killed when 2 police cars collided with each other like this in a neighborhood, one going 50 miles an hour and one going 65 miles an hour, responding to a routine non-emergency call. And one vehicle pushed the other vehicle up on the sidewalk and killed a father and his son who was in a stroller. And I can't make the city of Philadelphia change its training for police officers, and I can't make them change their rules for the operation of police vehicles. I can't do it formally. But I made a hell of a stink about what happened in this case, and in a study that we undertook of police vehicle accidents in Philadelphia, that there had been an absolutely staggering number of police vehicle accidents. Staggering, with injuries and deaths and property damage. And we would not settle that case absent reforms, and the city agreed to very substantial reforms of training and of police vehicle operation. So I think that the defendants are willing to listen. And of course, it's obviously very important to society that we obtain these reforms, because just, for example, with the police vehicle situation, anyone who's a pedestrian in Philadelphia or a motorist is at risk for a police car that is speeding out of control for no good reason. And any of us can be in a vehicle. I mean, when you land in Morocco and you're presented with a car and you're told to get in the back seat and there's no seatbelt there, what are you going to do? You turn around and go back home? So these reforms are important and they're necessary and they're very meaningful for society at large. And we lawyers have a unique opportunity to communicate what can be done to the next generation of lawyers. I teach at Penn Law School. I have for the last 17 years. I taught last night. And I try to impress upon my students the importance of what we do and how you should look at every single case as an opportunity to achieve structural reform. I had a young man who was a Master of Law student from India in my class a couple of years ago. And he went back to India and served as the law clerk to the Chief Justice of the Supreme Court of India. And they had a medical malpractice case in front of them. And with the judge's permission, he undertook to explain to the chief what the American system of justice was in medical malpractice cases and how India had essentially no viable system of compensating victims of medical malpractice. And he convinced the Chief Justice to adopt a system in India for compensation of victims of medical negligence that, while it doesn't quite get to our standards of fair compensation, it is leaps and bounds beyond what had been the case in India. So not only can we help ourselves and our own society, but this is exportable. We don't have to just export munitions, but we can export justice. And these opportunities are there, but we lawyers who have learned these things, we need to move forward with that in a constructive way with the next generation of lawyers. I'd like to close my observations on this with two comments. The most recent case that I had in this regard probably brought together the entire constellation of what I'm talking about with you today. It was a case called Goretzka versus West Penn Power. It involved a beautiful 39-year-old woman who was struck by a power line that fell in her front yard on a clear sunny day. And she was electrocuted in the most painful and horrific way imaginable in front of her two young daughters and her mother-in-law. And the line fell because it was improperly spliced and installed a few years earlier. It had fallen twice before. The power company linemen didn't know how to properly splice their lines. There really should have been a criminal prosecution in that case. But regrettably, we don't see prosecutors prosecute defendants in tort matters anymore ever since the Ford Pinto trial ended in a defense verdict for Ford in Indiana decades ago. Prosecutors won't take on that expensive battle. But I had a client, the decedent's husband, who wanted his case tried in court, which was just fine with me. And we tried that case. We got a very large verdict, which was almost entirely paid. But along the way, we got the Public Utility Commission in Pennsylvania to engage in some of their own honest soul searching, because they had failed to police this power company. They had failed to follow up when this incident occurred, even though it involved a death. They had failed to make proper inquiry. They had failed to investigate. They had failed to follow up when the company stonewalled them. And I publicly explained to the Utility Commission and to the news media how they had failed in their job, and they reformed themselves. They went forward and brought an enforcement action against the power company. They required the power company to inspect all their lines at regular intervals to fix the defective splices. They fined the company, and they established a new division at the Commission for the investigation of incidents like this, so that this summer, when this same power company had another power line fall in eastern Pennsylvania, killing a 31-year-old father, husband, teacher in front of his wife, the PUC in Pennsylvania sent 3 investigators to the scene right away, senior people, to investigate this matter. And I'm proud of my law firm for being able to produce a result like that for the people of Pennsylvania, because it means that we're really doing something to try to make not only our lives more just, but our society more safe. So my hat's off to Ralph Nader for this fantastic conference. And thank you very much for your rapt attention, and enjoy your lunch.